Good morning. Happy Thursday. We're closing in on the weekend, kids. I know I'm excited. Hopefully I'll be able to relax this weekend, but somehow I doubt it. Somehow I think I'll be moving and grooving again, which is unfortunate, but what are you going to do? Life comes at you fast. So let's talk about Matsumishi versus the DHS and all the misunderstandings that have spawned from it. Number one, it was a district court case. It wasn't an appellate case. There is zero precedential value in anything that comes out of a district court. It is not precedent. It's not even persuasive. It is just a district court case. So if you're hanging your hat on Matsumishi being precedential, you're sadly mistaken. Don't believe me? Google it. District courts do not set precedent. You need an appellate level decision or higher to set precedent. Next thing is, it wasn't actually a decision. It was a stipulated agreement between the parties. And stipulated agreements between the parties are just that. They're just between the parties. And the effect of violating a stipulated agreement is the other party can get an order to show cause for contempt. And basically it's like a quasi-criminal. It's a civil criminal thing. And the court may firmly suggest that you actually comply with the terms of the stipulation, or maybe they'll fine you a small amount of money or something. It's generally not that big of a deal. So in no way, shape, or form is Matsumishi anything to cite. It is nothing to cite. If you're NJ Diver and you like dropping links, maybe you'll mention it because NJ Diver is the coolest YouTube lawyer ever with his links. But that's really the end of its usefulness. Now, after I just said that's the end of its usefulness, here's some more usefulness from it. If you look at the fact pattern, you can see why the DHS was willing to settle it, and why the ACLU was interested. You're not chasing that skunk, dude. I don't care. And why the ACLU was interested in representing Matsumishi. Matsumishi was an upstanding citizen. He's like a stockbroker or something. He is a useful member of society. He didn't swear, he didn't shout, he didn't do anything wrong. He was there to interview somebody. I don't remember exactly the details of it. I think the guy was a jury nullification advocate or something. I don't know, but the guy was going to be there protesting at that plaza. Now the plaza was used every day by all sorts of people doing all sorts of things. They'd eat their lunch there. Apparently there was a court that opened up on this particular plaza where people got married, and they'd come out and they'd get their pictures taken on the courthouse steps. You know, just married pictures. So photography was a thing there. It was not enforced. Any regulations against photography were not enforced in this plaza. And this plaza appeared to be just a traditional public forum in every sense of the word. However, it was not. So when Matsumishi went out there to film, he attracted the ire of the FPS, who was there trying to bust the balls of the protester, who was busting the balls of the protester. Because they didn't allow protesting there. But now Matsumishi caught their eye, and it is viewpoint discrimination. Because they don't care if anybody takes pictures, but they do care if you take pictures of the protester guy. That's viewpoint discrimination. And remember, even in a non-public forum, the regulation has to be, number one, reasonable, and it might not have been reasonable in that particular open plaza to have restrictions against filming. We don't know. But number two, it also has to be viewpoint neutral. And because they didn't like the protester, they were all of a sudden enforcing this law. Now, it might have been on its face viewpoint neutral, but in the way it was applied, it was certainly not viewpoint neutral. So you could see the test that everybody doesn't like at work. And you could see how in this instance it would have in fact worked out, or it should have worked out in Mitsumishi's favor. And so the DHS settled. Now, why was it the DHS and not the FPS? Well, if a police officer violates your rights, do you sue the police department or do you sue the city? Ding, ding, ding. There you go. You sue the city. You sue the budget making. You sue the company that determines where funds, or the company, the entity that determines where the funds go, and not the entity who receives its trickle of funding. So that's why the FPS is a sub-department of the DHS. So the DHS would defend their little sub-department. So now that we have that backstory out of the way, the stipulated agreement was, number one, the government did not say that they were doing anything wrong, but they did say that they would promulgate the stipulation was that the DHS would promulgate a memo explaining how their officers should interpret the photography portion of the GSA's regulation. 41 CFR 102-74.420 or something like that. It's been a long time since I've looked at it. So that's part of that was part of their agreement. Now remember, policy is, as auditors like to say, not law, and as I will say, it is generally not law. You may have to abide by policy, but it may not be law. It generally is not law. So that internal memo, that guideline that they made for their officers, isn't binding on anything, anyone, anytime, anywhere, except for the FPS officers who may get their hand slapped for violating it. That's it. And it doesn't apply to any other department. It doesn't even apply to the GSA. What, you say? But they were interpreting a GSA regulation. Yes, it is another department. GSA is not a member, a sub-agency of the Department of Homeland Security. It's I think it's independent, or it might be Department of Interior. But my initial instinct was to say it's independent, so I'm going to go with it's an independent agency. It sounds like it should be Department of Interior. Now I'm second-guessing myself. Never second-guess yourself. Stick with your original thought. So I'm going to say it's an independent agency, and they're not bound by anything that the DHS does. And they get to set their own regulations for their own properties, and they may change their regulations or interpret them differently, etc., at their own discretion. So bear that in mind. Now, the GSA doesn't own all the federal properties. The Department of Defense owns properties. Other agencies own properties, like the post office. A lot of the post offices are not owned. They're not GSA properties. They're owned actually by the post office. So bear that in mind. And even properties like federal courthouses that may be GSA properties, they may not have FPS personnel protecting them. Generally speaking, in a federal courthouse, you will have U.S. Marshals. U.S. Marshals are not members of the Department of Homeland Security. They are part of the Department of Justice. So they also do not answer. You were just going out of your way to wrap me up today. They are also not answerable to the FPS's memo. Even if the GSA rules apply to the courthouse, which they probably would if it's on GSA property, even if they do apply, you have to always remember that a court order can supersede them. And it specifically allows for a court order to ban photography. It specifically allows for it. That's one of the conditions. So all the stock that everybody has forever been placing in the DHS memo, and still do for whatever reason that I don't understand, is misplaced. It is absolutely a meaningless piece of paper unless you want to get an FPS officer in trouble. That's it. You can't sue on it or anything else. And I have made countless videos on this. This is basically another one of those videos. I can basically do DHS memo videos in my sleep at this point. It's pretty tiresome. Yeah, but I guess I have a whole new crop of people in here who haven't heard the DHS spiel, and they don't know why the DHS memo is garbage, and why, except for people like NJ Diver, it's not worth anything. It's not even worth wiping your ass with. And that's one of the big issues that I have with the people who spread out these links, and they take quotes out of context on cases and they throw them out there, is that number one, you have to understand the whole context of the case. You have to understand how it works. You have to have a basic understanding of civics to start with, which seems to be lacking in this community. Who is responsible for what level of authority can make binding decisions and binding precedent. Lots of silly things. But a lot of times I see people throwing out quotes on cases that, oh, it's just like a sentence. And boy, doesn't it look like it fits exactly what they're saying? Except what they don't understand is they don't understand either it's dicta or it's dealing with an entirely different field of law. You know, I see a lot of Fourth Amendment stuff thrown out in First Amendment cases, like you can't trespass the eyes. I came from a Fourth Amendment case. Now, I'm going to have people saying that it's a maxim from tort law. Sure, which also doesn't apply. So I also had another guy. I actually looked him up. He is an attorney, and the guy went to school for something like 20 years or something dumb. And he has all sorts of degrees in biochemistry. I mean, he's obviously a smart dude, right? This guy's a smart guy. Probably smarter than dumb old me. I'm just a first-year family law attorney. He's a big boy with nanotechnology degrees and biological sciences degrees and all sorts of fun stuff. And he said that, you know, if you're competent, basically, he said, if you're competent, you know, all you need is the first year of law school to be able to understand case law and give your clients good advice. And you know what? I'm going to go one step further. I said he's retarded because he's making a stupid point. Because if you're really competent, you don't need any law school to be able to read and understand case law. If you're really that smart, you could just crack open that case. You could read it. You could digest it. Maybe if you have a background in logic, maybe you could do it. But I think that we saw with Constitutional Kim that she wasn't competent. She doesn't understand what she's talking about. And so saying that if someone is super competent, if they're really smart, they could do it on the first year of law school, it's meaningless. It's a stupid statement. And if that idiot is watching, there is a group of people out there who are so smart that they lose all of their common sense. And he is one of them. Sue me. Have a good day.